how do manager situations play out in real life? On this channel, and in my business, Manager Method, I provide manager training that's designed to give practical tips to managers to drive performance, no matter what your organization does, but do it in a way that makes people want to work for and with you. To have impacts not just on business results, but also on all of your team's careers, and as a manager, to do it with more confidence and without spending more hours in the day. But I do this with my background, not just in HR, but also as a lawyer. I worked as a law firm lawyer. I was on employment cases all over the country in the US, and I worked in-house for leading global organizations, so I had to get really familiar with employment laws all around the world. And so I use that in my training because it really is designed to help managers drive performance, delegate, do all of these things, but also know what to do and say in different situations that can feel really challenging. And organizations sometimes can end up in hot water and end up spending a lot more money than manager training, cleaning up messes, often because someone did something that they thought was right. So on this channel, I'll be breaking down actual lawsuits once a month and talking about what happened and what managers can learn from. Not to name and shame, but to do very similarly to what I did in a video last year about a discrimination lawsuit against SHRM, the Society for Human Resource Management, which is the leading HR association in the world that talks about itself as best practices, but has gotten itself into hot water in a case that's scheduled to go to trial this summer in Colorado. But in it, I broke down a lot of the things that happen in plenty of other organizations. And so today, I'll talk about a case that was actually brought by the EEOC, the U.S. Equal Employment Opportunity Commission. And this is about things like medical leave at work. Now, for those not as familiar with employment litigation and what happens, if an employee wants to bring a discrimination, harassment, retaliation claim, often it has to start with the EEOC, a federal U.S. agency. And some states and cities have their own agencies, but at the federal level, the EEOC often takes these, and you have to first make a claim for a lot of different types of lawsuits, and then either they take it on for you, the EEOC will bring that lawsuit. That doesn't tend to happen that often. What happens more often is they go through your case and you get what's called a right to sue letter. So then you, either on your own as an employee, or you get a private lawyer who often only gets paid if you are successful, you settle, or you get a verdict. They take that on for you. But as I mentioned, the EEOC, it's pretty rare that they take on these cases. But there was a case that just in January of 2025 came to resolution. It came to a settlement. And it's super instructive for what happens in a lot of organizations and has lessons for HR and for managers. Now, in this lawsuit, and I'll provide the full citation in the description for those watching, but this is an organization out of Michigan that's whole purpose is to help to support those 55 and older, to help them to give enrichment and things like that so that they can live independently without going to more assisted care. And why I want to talk about this in particular is that sometimes you'll hear, like I'll see in the comments or I'll talk to individuals that work at nonprofits, and people might think, like working at a nonprofit, especially a mission-based organization, those must be fantastic places to work for. And they can, but every workplace is still a workplace. And often managers in those organizations haven't gotten training, or policies don't get reviewed. And so whether it's a nonprofit or other organizations like that are really mission-driven, you can have things that managers do and say that are problematic or could be done better, just like in a for-profit company. So in this organization, there's a variety of people working. There's more of the corporate function, like finance, everything that pretty much every business needs to run. They also had people like nurses, for example. Now, this case actually had a couple different individuals. So this, again, was brought by the EEOC, which is rare, but they're bringing it on these employees' behalf. And the two in particular, one was for more the business side, was an accountant. The other was a nurse. And so, again, these type of things you can see in any type of environment, corporate, restaurant, retail. But what you saw was both of these employees needed to take medical leave. Here, this was the FMLA, Family Medical Leave Act. In the U.S., that's unpaid medical leave that you can take, generally up to 12 weeks. And there have to be some other qualifications, like you have to have a certain type of medical condition. But one of these employees had depression and more mental needs for medical leave. The other had issues with brain and vision. And so in both situations, these employees took their leave. And when they were during their leave, both needed to extend it beyond the period of approved FMLA. So they were supposed to return, let's say December 31st. Those weren't the dates, but just December 31st. They both reached out a couple weeks before their respective leaves were going to end and had said for different reasons that they needed a bit more time, and each asked for unpaid leave. Each time it was limited. So one, in the accountant situation, she said that she needed 30 more days of unpaid leave and asked for that as an extension. In the nurse's case, she was waiting on a specific type of contact lens and wasn't sure exactly when she could get it. It could be as soon as literally 3 days after her FMLA was ending. It could be as much as a few weeks after that. But both asked for some extension, again, of unpaid leave. In each situation, the employees were told no. In one specifically, they asked HR, what can I do to get an accommodation to get that leave? And the HR representative's response was, you can return on the day that your FMLA expires. Both the employees were then let go because they didn't return. And the organization had a policy of saying, well, if you don't return from your medical leave, we consider that a voluntary resignation. And in this situation, for both employees, it took a good amount of time for the organization to find replacements for both. Both times, it took well beyond the period that those employees had asked for unpaid leave. So more than 30 days. One, I think it took close to 4 or 6 months to replace this person. But so at the end of the day, the EEOC brought this suit. And so a lot of people may be thinking, but their FMLA had expired. When that ends, isn't that an end? What are you supposed to do? But what plenty of managers and even HR don't sometimes realize is that under federal law in the U.S., there are other laws that, even aside from your policies, you can be required to give unpaid leave. And one of those is the Americans with Disabilities Act, ADA, which applies when you have 15 or more employees. So it's a different qualification than FMLA, which is a whole other calculation. But unpaid leave can be at times a reasonable accommodation under the ADA. And so in this situation, this policy, for example, that if people did not return at the end of their FMLA, then they automatically were considered a voluntary resignation. That was problematic because there wasn't even a conversation. Again, in one hand, an employee had asked for an accommodation, and the company didn't even give her the conversation. And so when the AEOC brought a lawsuit, the problem wasn't just FMLA because they both were exhausting their FMLA leave, but it was under the ADA. And the issue is that it's so important for managers and HR to be aware of in this situation was whether that leave is granted or not, or it's deemed a reasonable accommodation, you at least need to have a conversation. Generally, that conversation is going to be with HR. And so managers need to know what to do and say if an employee who's on leave is asking for this. In this situation, again, even the HR contact did not do the right thing. So when the EEOC brought this lawsuit, again, on behalf of these employees and any others, because especially when an organization has a policy like this, like we consider this a voluntary resignation, then the EEOC is like, okay, well, we're going to assume that there have been other employees who have impacted by this, so give us your records. So in this situation, it's an issue of the HR organization, but often managers are the point of contact for these conversations, but not realizing that there were other things that these employees would have been entitled to. Again, having a conversation. And at the end of the day, both of the employees, if they'd been given their unpaid leave, they would have been back working well before they ended up finding replacements for these people. So the EEOC takes the position like that would have been a reasonable accommodation to give this limited period of leave. But so what this meant in the EEOC, they've entered a consent decree. Basically, that's a settlement. So in January, this was made public. So there's a reason I know about this, because when the EEOC sues you and you have a settlement, it does become public. It becomes public record and other things. This employer had to pay $170,000. Some of it back pay, compensatory. They have to go through their records, determine if there's anyone else owed part of that money. So that's a big chunk of change, all based on a policy that clearly they thought was right. In addition, they have to do things like posting. So it's not just that this is publicly available. This is on, like the EEOC will post this on their website, but also as an employer, they have to post this in all of their different locations. So employees know about this. They have to have training to make sure that people understand and that they have the right policies in place, that things like this, including one of the other aspects in the consent decree was about not requiring a doctor's note when someone returns from their medical leave, not having that mandatory before they can necessarily return. And so in this situation, This took a lot of time and money. I guarantee you the legal fees in addition probably cost just as much, if not more than the $170,000 that they're having to pay to these employees. But what happens is often a breakdown in communication is a policy. In this situation, it's absolutely on HR and the legal team to make sure that your policies are compliant with laws. But it's also important that managers understand if you have someone that's going on medical leave, what are they entitled to? And one of the things that's most important for managers, this is what I talk about in training, is to have a mindset. Because frequently in these conversations, when someone's been out on medical leave and maybe they're asking for an extension, sometimes it's a rolled eyes or their responses or things like that. They come from a place of, what do we have to do? But those things don't tend to read well on paper. Like I've seen cases with emails like that, and you read it and you think, who would send that? And the answer is plenty of people. Because when you're a manager, you're often thinking about getting your work done. And so you're not thinking about the human lens of the people that you work with or what they may be going through. And so just knowing that as a manager, switching the perspective and helping managers understand the perspective of not what do we have to do, but what can we do to support employees and how you work with employees in that leave, even if as a manager, you're not the one necessarily making that decision and HR is handling it, showing those levels of support is so important. And so in this case, again, it starts with a policy that plenty of employers have. I've seen this time and time again. But not having these individual conversations and considerations about what people are entitled to. I know, so one of the things that's required is this training. I've done training for organizations that have been required by the EEOC as part of a similar settlement to have training that's for employees on accommodations for the deaf and hard of hearing. Oftentimes, a lot of remote environments have policies or even managers, hiring managers that think, well, they can't work here because we're remote first and they're deaf of hard of hearing. How's that even possible? And so they don't consider applicants or employees' needs. And so I've done that training. Again, I know what it looks like to have the EEOC have to go through your whole training deck and approve every slide. And so just knowing this is one of those cases that's so important for HR to make sure that your policies are up to date. Also for managers to have that training on what it looks like to have empathy and knowing how to filter communications, let people know, okay, if this isn't a conversation for you, how do you loop in HR in a way that employees feel supported rather than targeted? So this was a really helpful example to me because I've seen this time and time again. So I'll be breaking down more of these cases. And again, the point of this is to have takeaways for HR teams to understand how to think about your policies and things like that. I no longer practice law. All I do is manager training. But so to know that part of manager training and building these in can help so that you're not hit with one of these unexpected, very expensive bills based on one mistake or conversation that should have gone a different way. If you like these breakdowns and you'd like to understand manager training options for your organization, we do have very different options. One is scalable, where I have a manager 101 and then 201 courses where managers take on-demand videos with the resource guide. And we have materials that you and your HR and people teams can run follow-up live cohort sessions to drive those home. And those can be customized. You have everything you need from talking points to run those effectively at budget. We also do customized presentations. I've done ones where I actually walk through example legal cases and identify some of these things, but also customized role plays and other options for your organization to make sure that it's the solution that helps you empower your managers to have the impact on the whole organization. So feel free to go to the description to learn more.